separated. Mr. Steiger, go ahead with your opening statement.
Thank you, Professor Smith. As you articulated twice when we had our conferences on discovery issues yesterday, there are two issues in this matter. The first is the violation by the various parties supporting the Libertarian candidates for governor and lieutenant governor of Revised Code Section 3501.38 in terms of the petitions that were filed to support the candidates being placed on the ballot. As you know, 3501.38 says that the circulator shall, a mandatory term, identify the name and address, quote, of each person employing the circulator to circulate the petition. And indeed, under 3513.05, if there's failure to fully comply, the statutory word fully comply, then that petition shall be deemed invalid and be rejected. Those are mandatory provisions of the Ohio Revised Code designed to protect the electorate against voter fraud and manipulation. Here, a majority, over 900 of the petition signatures submitted on behalf of the candidates of the Libertarian Party for governor and lieutenant governor failed to comply with those statutes. The facts, I don't believe, are going to be in serious dispute. The Libertarian Party hired Oscar Hatchett Jr. and paid Oscar Hatchett Jr. to go out and collect approximately 660 of the nearly 1,500 petitions that were filed on behalf of those candidates. But you will see in Exhibit P14 the part petitions Mr. Hatchett circulated with approximately 660 signatures. Not one of them identifies the statutorily required name and address of the person employing the circulator. Indeed, from the face of the documents, it would appear that Mr. Hatchett did this out of his own volition rather than being a paid partisan circulator. As such, Mr. Hatchett's petitions that he circulated violate 3501.38 and are invalid under 3513.05. But there's more. Mr. Hatchett, we believe, the evidence will show, retained a lady by the name of Sarah Hart, who is also a paid professional circulator, as the evidence will show. And Sarah Hart also circulated petitions on behalf of the Libertarian candidates. She collected an additional 241 signatures out of their nearly 1,500 signatures. But again, if you look at Exhibit 22, the petitions that she circulated, again, not one of them complies with 3501.38, and thus they are invalid because she did not disclose the name or address of the person paying for those petitions. So we believe the evidence, Professor Smith, will show that 901 of the signatures contained on the part petitions supporting the candidacy of the Libertarian candidate for governor and for lieutenant governor were invalid as a matter of law on the face of the statute for absolute noncompliance. We do understand that there are arguments between the parties as to whether these people were independent contractors or merely employees. The law, as set forth in our brief, is clear that it makes no difference. Indeed, the Secretary of State of this state, Mr. Husted, has already held in pleadings filed in a federal proceeding that it doesn't make any difference as long as there is a payment. And let me restate that. It was not a federal proceeding, it was a state proceeding. And in fact, the Ohio Supreme Court in that proceeding said that his decision on that was entitled to deference and is controlling. So the controlling law that is before you today is that whether Ms. Hatchett, or Mr. Hatchett, or Ms. Hart are employees or independent contractors is irrelevant. The fact they were paid and failed to disclose it violates the two statutes. Their part petitions are invalid. When you invalidate them, the candidate must be